Supreme Court of Georgia has responded to Yak Gotti's petition for a writ mandamus regarding the recusal of Judge Glanville, right? They deny it, saying he should instead file it in the Fulton Superior Court and have another judge than Glanville rule on the writ. This YSL RICO trial has not disappointed when it comes to entertainment, when it comes to us learning a lot about the law. And most recently, we found out that the Supreme Court, the Georgia Supreme Court, has made a ruling when it comes to the motion that Attorney Weinstein was trying to get passed by the Supreme Court. All right, so y'all check this out. We're going to read through his tweet here in a second, but basically, Mr. Weinstein, or Attorney Weinstein, was pressuring the Georgia Supreme Court because there have been so many motions to recuse Judge Glanville, because in this case, it's looking like he has been pretty biased. Again, the jury's still out on that, pun intended. But when it comes to Judge Glanville, there has been clear push to get him off of this case. So most recently, and within the last 24 hours, the Supreme Court handed out their ruling, and it shows that they denied his motion. All right, so we're going to read here. Actually, Attorney Weinstein posted this on his Twitter account. So shout out to him for sharing this and posting this so we can kind of see and understand what the Supreme Court is saying. All right, so he says the Supreme Court of Georgia has denied Mr. Kendrick's petition for writ mandamus. All right, and we talked about that in past videos. If y'all missed it, I'll pin the video and y'all can go back and watch it as well. Based on a requirement that we must first petition Fulton County Superior Court. Court notes that the petition must be heard by a judge other than C.J. Glanville. We are not done seeking relief. So initially listening to his statement, it kind of sounds like a loss on the defense's side, only because it's just another process they have to go through. Now, it is nice that the Supreme Court kind of laid out how they want them to go through the entire process. Also, as you heard in this statement, Judge Glanville has some of his power taken away. He's not going to be able to rule on the next motion that is brought up against him. So that could be a plus. It could be a minus, because they're going to have to bring the next motion to the Supreme Court, or to another, not to the Supreme Court, excuse me. They're going to have to bring that motion before another judge. And we know, y'all know where you work. Y'all know, and may not know how attorneys work, but they all know each other. They work together. So this could be a potential L, because if Judge Glanville is friends with a lot of these judges in Fulton County, and they send this motion to another judge that's friends with him, doesn't want to get him removed, they could deny this as well. So it is nice that they have now a clear path in the way they have to go about things. And if they have to send something else to the Supreme Court, they can. But I wanted to read through this statement from the Supreme Court so we can actually get their wording and kind of understand what they're saying here as well. All right, so this is the Supreme Court of Georgia, and this was sent yesterday. The Honorable Supreme Court met pursuant to adjournment. All right, the following order was passed. DeMonte Kendrick versus Earl Glanville, or Judge Glanville. Petitioner DeMonte Kendrick, who is facing trial on murder and other charges in Fulton County, filed directly in this court an emergency motion seeking original relief in the form of mandamus against Chief Judge Earl Glanville and a stay of proceedings. Basically, they wanted the Supreme Court to step in because they just felt like they weren't going to get anywhere with Judge Glanville. Kendrick filed in the Superior Court a motion to recuse Chief Judge Glanville after he became aware of an alleged ex parte meeting on June 12, 2024. Between the judge, assistant district attorneys, a state witness, and the witness's attorney, which y'all know is Kayla Bumpkus, and we're actually going to talk about her later, right? Chief Judge Glanville did not refer Kendrick's motion to recuse to another judge, see Uniform Superior Court Rule 25.3, and instead decided the motion himself and denied it. Okay, which they're saying, and they're quoting here that he's not able to do that. It says, when a trial judge is presented with a motion to recuse or disqualify accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness. Oh my gosh, that word's crazy, of the motion and the legal sufficiency of the affidavit, and make a determination assuming any of the facts alleged in the affidavit to be true. whether recusal would be warranted. All right. So they're basically saying you got to go through the proper chains. Glanville can't say, no, we're not going to do that. It needs to go to another judge to decide, which seems like he was totally fine with doing that. Not once, not twice, but several and multiple times. It is found that the motion is timely, the affidavit sufficient, and that the recusal would be authorized if some or all the facts set forth in the affidavit are true. Another judge shall be assigned to hear the motion to recuse. The allegations of the, and then it goes on. All right. In his emergency motion, Kendrick does not seek appellate review of the order denying his motion to recuse. Instead, he seeks original relief from the court against Chief Judge Glanville, asserting that any effort to file a petition for writ mandamus in Superior Court would result in frustration and lack of action, which is kind of what we just talked about and mentioned. They're basically saying, Supreme Court, please step in, because we know we're going to take this to Glanville and he's not going to go through the proper actions. He's not going to allow us to show this to another judge. He's going to refuse it and we're just going to be wasting our time. So just go ahead and handle this, right? All right. So it says would result in frustration and lack of action because such a petition would go to Chief Judge Glanville. And so he has no option other than for the Georgia Supreme Court to exercise indiscretion and consider his claims. By way of relief, Kendrick requests that the court directs Chief Judge Glanville to adhere to Georgia Uniform Court Rule 25.3, which we just talked about, and assign his motion to recuse to an unbiased judge for a hearing. Well, yeah, that's going to be tough. Oh, shout out to Henry Resilient. He said this is not centered. Thank you, Henry. I got you. All right, we should be good there. Sorry about that, y'all. So we'll do this. Boom. All right, thank you, Henry. I appreciate it. All right, so where were we? Said by way of relief, Kendrick requests that this court direct Chief Judge Glanville to adhere to Uniform Superior Court Rule 25.3 and assign his motion to recuse to an unbiased judge for a hearing. Again, I mentioned one of the roadblocks you might see there is Judge Glanville. He is the chief judge in Fulton County. So say he refers it to someone else in Fulton County, or it gets referred to another judge in Fulton County. Who's to say that they're unbiased? I would just assume that judges are going to look out for other judges unless he has something against another judge, which I guess is possible, but it seems highly unlikely with him being the chief judge, right? That the court stay in trial proceedings pending resolution of the motion to recuse, and that the court order Chief Judge Glanville to produce an unredacted transcript of the secret ex parte proceedings held on June 12th. Man, if they could get this through, that would be amazing, but we'll see what the Supreme Court says. Although this court has the power to grant original relief in the nature of mandamus, they said we could do it, but it has chosen to maintain its general status as an appellate court and to exercise its original jurisdiction only in extremely rare situations. Dang. That's tough. Now, again, I see this as kind of an L just because there's so much more time that they're going to have to go through to follow this procedure. You guys see Judge Glanville already pushed Caleb Bumpkiss's hearing to the 3rd. So we still have to wait a whole nother week for that. Who's to say that they're not going to sit on this? They're not going to take their time, and then they go through the process. And then the judge, the unbiased judge, says, no, we're not going to grant you your certificate. Then they have to go through the Supreme Court again. I mean, we're looking at a minimum of what, 2-3 weeks that we have to wait for Attorney Weinstein to start this process over, which is a shame because we definitely wanted to see a ruling quickly. Either way, where need has been shown. Okay. And before this court will consider exercising its original jurisdiction, the petitioner must show that he has sought and been denied access to the proper channels for seeking relief in the trial court. So basically they have to do everything they can. We already mentioned that. And then the Supreme Court will look at it. Moreover, it is well established that a petitioner seeking mandamus relief against the Superior Court judge may file such a petition in the appropriate Superior Court. And being the respondent, the Superior Court judge will disqualify another Superior Court judge will be appointed to hear and determine the matter, and the final decision may be appealed to the appropriate appellate court for review. Again, they're saying just go through the process and then we'll look at it once we get there. Here, before seeking original mandamus relief from the court, Kendrick is required to show that he first sought and was denied access to the proper channels for seeking relief in superior court. Can't skip steps. That's what they say. And Kendrick has not made such a showing, and he admits that he has not filed a standalone mandamus petition against Chief Judge Glanville in superior court. Although Kendrick expresses concern that filing a mandamus petition in superior court would be futile because the petition would be assigned to Chief Judge Glanville, that is not so. As explained in Brown, if Kendrick were to file a mandamus petition in superior court naming Chief Judge Glanville as the respondent, Chief Judge Glanville will be disqualified presiding over the matter. Okay, a different judge would consider Kendrick's petition, and either party may appeal the final decision. All right, see Brown. Accordingly, Kendrick's emergency petition for writ of mandamus and stay of proceedings is dismissed. All right, so y'all let me know what you think. Is this a win? Is this an L for the defense? It's looking like the Supreme Court's doing their job. They say, hey, I get what you guys are saying. It's frustrating, but we have to go through the proper channels first. So I know that attorney Weinstein is going to start the process over again and go through that. We'll have to wait and see what happens, especially with us having to wait to get back to court. When is Judge Glanville even going to hear this, and how fast are they going to be able to move here? Another thing I thought was interesting about this, we got to go over to Thugger Daily, and shout out to Thugger Daily. I will post the link in the description to Thugger Daily over on X. If you're really interested and intrigued about this case, Thugger Daily on X has really been on top of getting all these documents, giving updates on what's going on in the court, nitty breaking news. So this is where I get a lot of the information from and a lot of the documents as well. So y'all go make sure you show Thugger Daily some love. But Thugger Daily lays everything out and explains what's going on and how the process is going to go from here a little bit better as well. Supreme Court of Georgia has responded to Yak Gotti's petition for a writ mandamus regarding the recusal of Judge Glanville, right? They deny it, saying he should instead file it in the Fulton Superior Court and have another judge than Glanville rule on the writ. All right, so basically the Supreme Court is the last resort in the motion. Yak Gotti's lawyer mentioned they skipped Fulton County Superior Court because it would have gone to Glanville, but the Superior Court specifically says that Glanville will be disqualified from ruling here. Now, that is somewhat of a win because they're saying, all right, Glanville, you're done. You're out of it. We're taking away your power. Now, if something gets filed, it has to go to another judge. But also, who's the judge is going to go to? So once it is filed correctly, it will go to another Superior Court judge who is supposed to rule on mandating the chief judge to refer a motion to recuse himself. All right, it goes without saying that that's insane pressure, but even if they deny it, they're infinitely more likely than, if it goes insane pressure, they're infinitely more likely than Glanville to grant a certificate of immediate review on their ruling for immediate appeal, which definitely makes sense, right? So then we've got, do note that the Supreme Court of Georgia uses a footnote to specifically highlight where Glanville screwed up. Okay, we skipped over this a little bit, but I read through it. Let's see what they say. Am I naive in having faith in the Superior Court judge that is going to pick this petition up? I don't know, man. Seeing how everything has gone in this case, in the Trump case, in the Fani Willis and Nathan Wade case, I do not have any faith whatsoever. Dang, should I say this on live stream? I'm in Fulton County in this current Fulton County YSL trial. I'll put it that way, but we'll just have to wait and see. You guys will have to let me know in the comments. Obviously, Weinstein is going to go through the correct process to get this moved around, but I have a feeling we're going to end up right back where we were at the Supreme Court, and then we'll have to wait and see where they move from there. But it's looking like this is going to be another 3 to 6 week process because there's really no incentive, not only for Judge Glanville, but for the unbiased judge ruling on this to move this through quickly. And I'm sure whoever gets this on their desk is going to be very conflicted.